Sources of public international law. There are two types of sources of public international law. They are 1. Formal sources and 2. Material sources. A formal source refers to the legal procedures and methods for the creations of rules of general application legally binding the persons or bodies at whom they are directed. On the other hand, material sources provide evidence of the existence of rules which when proved have the status of legally binding rules of general application. In other words, a formal source is that from which a rule of law derives its force and validity. The material sources supply the substance of the rule to which the formal sources give the force and nature of law. Article 38, Paragraph 1 of the Statute of International Court of Justice, which was adopted from the same article of the Statute of the Permanent Court of International Justice, provides that the court whose function is to decide in accordance with international law such disputes are submitted to it shall apply. A. International conventions, whether general or particular, establishing rules expressly recognized by the contesting states. B. International custom as evidence of general practice accepted as law. C. The general principles of law recognized by civilized nations. D. Subject to the provisions of Article 59, judicial decisions and the teachings of the most highly qualified publicists of various nations as subsidiary means for the determination of rules of law. Article 59 provides that the decisions of the ICJ have no binding force except between the parties and in respect within that particular case. According to Article 38, Paragraph 2 of the above-mentioned statute, the court is empowered to decide a case ex equo et bono if the parties agree thereto. 1. Treaties. A treaty is any international agreement entered into by two or more states or any other international law persons and governed by international law. A distinction is normally made between law-making treaties, multilateral treaties, and treaty contracts, that is, those that are entered into between two states dealing with the particular matter between or concerning those states exclusively. Bilateral treaties. States or other international law persons are bound by treaties which have been regularly concluded and have entered into force. States under the principle of pacta sunt servanda. Under this principle, parties to treaties are bound to observe and carry out the obligations in good faith. This principle, which is in itself the rule of customary international law, is the basis of positive international law upon which the entire superstructure of contemporary international law depends. 2. Custom. To become a binding rule, the custom must have been practiced and accepted as obligatory by the international community. State practice distinguishes between general and regional custom. General customs are those customary rules that bind the international community as a whole, whereas local or regional customs are those applicable to a group of states or just two states to be a relation among themselves. 3. General principles of law. The statute of the ICJ allows the court to apply general principles of law recognized by civilized nations. The general principles are those which are accepted by all nations in their domestic law system, such as certain principles of procedure, principle of natural justice, principles of good faith, and the principle of res judicata. 4. Judicial decisions and writings of publicists. Although in theory there is the barrier to the adoption of the doctrine of precedent, in practice the decisions of the ICJ are treated as having the highest authority. State parties to cases that come before the court frequently make reference decisions of various international tribunals. Even in practice, the court itself has of necessity followed previous decisions in the interest of judicial consistency and has where necessary distinguished its previous decisions from the case actually being heard. In relation to writings, although writings of publicists only constitute evidence of customary law, learned writings can also play a subsidiary role in development of new rules of law. For instance, the contributions of writers such as Hugo Grotius and Gentili were very important to the formulation and development of international law. Besides, writers of international reputation such as Oppenheim are often relied upon by legal advisors to states, tribunals and courts. Other sources of international law. 1. Resolutions. recommendations and declarations of the U.N. General Assembly are often resorted to not only their persuasive value on international duties and obligations but also as evidence of political consensus on various international relations disputes. The resolutions may also have very significant influence on the subsequent development of international law and practice. 2. Decisions of the U.N. Security Council taken in exercise of the powers conferred upon it by the Charter, especially under Chapter 7, are binding on states. This is based on the functions and powers of the Security Council as provided for under Article 24 and 25 of the U.N. Charter, read together with Article 103, which provides that in the event of the conflict between the obligations of the members of the UN under the Charter and their obligations under any other international agreement, their obligations under the Charter shall prevail. 3. In some instances, unilateral declarations of states may give rise to binding international legal obligations. In such instances, the intentions of the state making the declaration in question to be bound is crucial, as will be the element of publicity or notoriety.